Please start.
Okay, ma'am. A very good evening to you, sir, and everyone who is present in the meeting. I am Dipali Padi, the coordinator at LawInternship and the moderator for today's interactive session organized by LawInternship. Today, we have among us Advocate Gautam Pratap Rai Matani, sir. Sir is a richly experienced personnel in corporate and cyber laws. He has always been helm of leadership positions from being a GDPR and GST practitioner to a trademark attorney. Sir is currently working at MKU Limited as an in-house legal and IPR counsel head. He has driven massive legal work system ranging from international laws and expert compliances to the Ministry of Defense. He is an alumnus of University of Leeds, England, and has previously been associated with reputed organizations such as Supremo Amicus, Indian Legal Solutions, and Legal Desire. He engaged himself with the international lawyers for setting up of companies and drafting JV agreements. He is expertised in technology transfer agreements, copyright registration, trademark objection or opposition reply, and taxation related queries. He is well versed with the drafting of agreements between the international corporations and government agencies. So we welcome you, sir.
Thank you, Ms. Dipali, for the introduction.
Yes, sir. So today, sir will be discussing on how can IPR help in enhancement of future lawyers. So I request the participants to turn on their videos and keep their mics on mute. So if anyone has any kind of query, you can raise your hand and you can ask to sir, or else you can write it in the chat box itself. So without any further delay, let's begin the session for today. Over to you, sir.
Thank you. A very good evening to all of you present over here. I wouldn't conduct it as a one-time or one-way speaking session. Instead, I would like that each and every one of you have some inputs or some questions or some queries for me. So, how much is the time for the webinar?
So it's minimum of 1 hour and rest you can take it further also.
Okay, so we shall do it for 20-25 minutes. We can just have a brief, then we can have a 10-15 minutes of Q&A round, and then again 20-25 minutes, and then again a Q&A round of 10-15 minutes.
Definitely.
So anyone has any doubts, any problems, let's make it interactive. Let me extend a hearty welcome to all while thanking all of you making this webinar possible. I sincerely hope that you all will go back at the end of this conference intellectually enriched and positively stimulated with a clear idea of how IP laws help in enhancing the future. Now, there are many noble pursuits in the world of law. Everyone is aware about that. But whether you are just starting out or have been practicing for a while, you will definitely be familiar with two words: intellectual property. So, anyone who can tell me what comes to your mind when you hear the words intellectual and property? Anyone from the participants can tell me anything which comes or strikes to your mind on the first phase when you say okay, intellectual property?
So is it protection to our innovation?
Okay. Anyone else? Anyone can speak up anything, whatever comes to your mind.
Maintaining the originality of a creation, artistic creation, or like that.
Okay, Gaurav. Anyone else? So, intellectual property, also known as IP law, is a significant legal field that continues to expand its importance. बहुत layman terms में समझते हैं what is intellectual property. Intellectual means anything which is generated through your intellect, or I would say in a layman's word, through your brains. And property means संपदा. So बौद्धिक संपदा. जब आप लोग घर पे प्रॉपर्टी खरीदते हैं, गाड़ी खरीदते हैं, तो एक प्रॉपर्टी बनाते हैं. वो प्रॉपर्टी होती है जो आप जिसको देख सकते हैं, सुन सकते हैं और उसको छू सकते हैं. बट इंटेलेक्चुअल प्रॉपर्टी वो प्रॉपर्टी होती है जो कि आपके ब्रेन से, यानी कि आपके माइंड से या फिर आपके इंटेलेक्ट से जनरेट होती है. इसलिए हम लोग उसको बौद्धिक संपदा कहते हैं। माइंड से जनरेट की हुई हमारी प्रॉपर्टी जो कि बौद्धिक संपदा कहलाती है। There is a constant evaluation of creative ideas in a diverse range of industries, and these are considered property much like estates or a car. This area of law is responsible for their rights and protection. IP is the legal protection of creative property. However, faces a wide range of commercially valuable creations, including artistic work, patents, industrial processes, any kinds of protection such as trademarks, trade secrets, copyright, patents, design applications, and geographical indications. IP protects both concrete and results of an idea as well as the intangible ideas themselves. IP's ultimate purpose is to safeguard intellectual properties against misuse or theft, as well as to protect their owners from financial loss. A lawyer specializing in intellectual property may encounter cases of duplicate or infringement, as well as agree on the usage of rights of a new product or service. In order to manage them successfully, lawyers will frequently need to specialize in one or two areas like trademark, copyright, or patent, with specialization or necessities as and when they desire. So, is everyone clear what is intellectual property, or does anyone has any questions regarding that? Anyone has any questions, you can type in the chat box, you can just ask me right now. That you have understood in the layman's language intellectual property क्या होती है? What does an intellectual property law career entail? A large portion of IP lawyers' employment will entail giving legal guidance on a variety of topics ranging from commercial viability, marketing, to ownership, vesting, and infringement. On a daily basis, a variety of tasks may be carried out, ranging from emailing a party who is infringing on a client's work to checking patent registries, trademark registries on behalf of your new idea. So let us start with the first basic thing, which is trademark. So what do you understand by the term trademark when it comes to your mind? Anyone who can tell me what is a trademark and how do you protect it? Anyone?
I think many of them are writing in the chat box itself, so I think we should wait some more time. But
okay. So anyone can tell me what is a trademark on a simple layman's language? आप unmute करके भी बोल सकते हैं, chat box में जा सकते हैं. Sameer, a special symbol. Okay, very nice. Anyone else? लॉ इंटर्नशिप्स की लोगो का जो आपको ये दिख रहा है, जिसमें एक I guess there is one taraju, then there is some kind of university, and then there is some kind of pen. Can everyone see the law internships logo which is there, where it is written? There are 3 demonstrations, and then it is written law internships, the online law school. Yes. Sana, any design? No, I wouldn't say Sana, it's any design. It's only a particular symbol, registered symbol of words, right, Shishti? Gora, a unique symbol to specify a brand or organization. Very nice. So trademark. अब ट्रेडमार्क कभी भी कोई भी प्रोडक्ट लॉन्च होता है या कंपनी बनती है तो उनका एक अपना यूनिक सिंबल चाहिए होता है जिससे कि उनकी पहचान हो सके कि ट्रेडमार्क क्या होता है. So when we are going for a particular field, for example, in coming years you are going to be future lawyers, and if you think, okay, now I need to become a trademark attorney, or I would like to practice in the field of trademark, because IPR in itself is a very vast field. So trademark, the first thing you need to do is you need to know there are around 45 classes. A total of 45 classes are there in which you can register your trademark. From 1 to 35 exists for the manufacturing sector, and from 36 to 45 exists for the services and for traders. हर क्लास की एक स्पेसिफिकेशंस है. फॉर एग्जांपल, अगर आपको मेडिकल क्लास में जाना है तो क्लास 5 आएगी. अगर आपको ऑनलाइन बिजनेस किसी को सजेस्ट करना है तो क्लास 35 आएगी. तो बेसिकली आप क्या कर सकते हैं, ट्रेडमार्क पोर्टल खोल सकते हैं, उसमें कोई भी रैंडम नाम डालिए. ठीक है, उसमें आप सर्च करिए, फॉर एग्जांपल वी टेक एन एग्जांपल ऑफ रिलायंस, आपने रिलायंस डाला और रिलायंस किसी भी जो भी बिजनेस वो करता है उससे उसकी क्लास देख लीजिए कि किस क्लास में उसका बिजनेस फॉल करेगा। फॉर एग्जांपल मोबाइल का जो जियो है, तो उसमें जाके आप सर्च कर सकते हैं, ओके ये रिलायंस का ट्रेडमार्क है। जब आप रिलायंस के ट्रेडमार्क को चेक करते हैं तो आपको ये भी दिखता है कि वहां पे एक एप्लीकेशन नंबर लिखी रहती है। उस एप्लीकेशन नंबर को आप फिर से एक पोर्टल खोल सकते हैं, ट्रेडमार्क सर्च बाय एप्लीकेशन नंबर। यू कैन नोट ऑल दीस थिंग्स डाउन आल्सो, और ये इजी रहेगा आपको कभी भी कोई भी ट्रेडमार्क सर्च कंडक्ट करने में कि ट्रेडमार्क एप्लीकेशन नंबर से आपने उसको सर्च किया। जब आप उसको उस तरीके से सर्च करते हैं तो आपके पास एक लिस्ट ऑफ डॉक्यूमेंट्स आते हैं जिसमें आप देख सकते हैं कि अपलोडेड डॉक्यूमेंट्स क्या हैं, कैसे हुआ, कैसे पावर ऑफ अटॉर्नी लगी, कैसे ट्रेडमार्क एप्लीकेशन फॉर्म जनरेट हुआ, और फॉर्म जनरेट हो जाने के बाद कैसे अटॉर्नीज ने उस ट्रेडमार्क को अप्लाई किया। तो सर्च रिपोर्ट पे जब भी मान लीजिए आज आपके अगल बगल ही कोई भी एक लेमैन आदमी है जिसको ट्रेडमार्क कराना है, आप उसको सजेस्ट कर सकते हैं वो ट्रेडमार्क उसको मिलेगा या नहीं मिलेगा। एक ट्रेडमार्क सर्च के पोर्टल पे जाके उस पर्टिकुलर क्लास में या क्लास जिस क्लास में वो फॉलो इन करता है और 2-3 सिमिलर क्लासेस में सर्च करके कि ट्रेडमार्क अवेलेबल है भी या नहीं। Am I clear on the part of trademark? So I would move ahead on patent.
Sir,
Anyone else have any doubts on that? Anyone has any questions on trademark?
Sir, I don't think anyone has any questions, so we can proceed.
So nowadays, due to surge in technology, a flood of media, and an expanded ability to disseminate information, intellectual property litigation is witnessing a large increase in demand.
So your mic is on mute.
Okay. So, due to a surge in technology, a flood of media, and an expanded ability to disseminate information, intellectual property litigation is witnessing a large increase in demand as of a result of the brand, demand, and scope of specialization. Aspiring IP lawyers have a lots of options to progress. Patent law is a popular target for recruiters due to recent low numbers and specific qualifications that are necessary, often some degree of technical or scientific training at the bachelor's level. Their area of expertise are oftenly classified as physics, pharmacology, or medicine, or maybe electrical engineering or normal engineering. So anyone who is desiring to become a patent attorney or a patent agent, a person has to have a electrical background, or I would say a science background, to become a patent agent or a patent attorney. Now, let's talk about the main fields. There are total 6 fields. One is trademark, patent, copyright, industrial designs, geographical indications, layout designs. So how can students specialize in intellectual property laws? Law students can be divided into 3 groups: those with strong academics, good internships, and those with both. The third category is with the majority of students falling for first or the second categories. Making a decision is never late. Every law school has a group of alumni, begin networking with others, reach out to them, and learn from their experiences. This isn't limited to IPR. You will get to know about which field you need to go into deep and to research, and to choose one area of law in which you want to have your specialization done. You can enroll yourself in IP laws specialized courses, and you can have a practical training of experts on different courses which have been available online. You can plan your internships in IP specialized law firms or advocates, in which you will get to know a deeper knowledge. Okay, how do we do trademarks? How do we go into copyright and everything? Now coming to the patent section. So what you can do in a patent is, like there's a portal for trademark search, there's a similar portal for copyright and patent. So what you can do is you can directly go to the patent search portal. It's a very generic portal. If you just put it into Google patent search, you will get into the portal. And you can just type in what kind of patent you need to search upon. For example, if you need to search upon a patent, Hero has put in for electric scooters. So what you can do is, in the name of the title, you can put in electric scooters. So you would get all the patents which have been, and you can select the year also, like you want in 2020, 21, or ranging between somewhere. So you would get to know, okay, these are the electric vehicle patents which have been applied by people. A patent when applied, it takes around 6 months to publish the patent, and after that the public patent is published, then only you can see the patent on the patent portal. It doesn't mean that when you apply the patent, you can see the patent, but it appears after a period of 6 months. In trademark, such a thing doesn't happen. When you apply a trademark, the very next day, you get an application number and you can search it from there. So in trademark, there's a very simple procedure. You apply the trademark, you get an application number. After that, the registrar examines the trademark. And then there are two objections which comes in section 9 and section 11 of the act. After getting an objection, you need to submit a reply within a period of 1 month. For example, if you do not get an objection, your trademark gets published in the journal for a period of 4 months. And if for a period of 4 months, no third party raises an opposition against it, your trademark is granted. But if any party raises an opposition, then you have a time period of 2 months to submit a reply to the opposition, and then you have to go for a hearing and clear out your client's trademark. Okay, we have been using from this. Now, one very, very peculiar thing about trademark is the user date, which generally people do not keep in mind. For example, it might be possible that your client has been using the particular logo from a period of 2 years. But when you're filing it, you put it as proposed to be used. So in that case, the trademark would be accepted or would be, I would say, validated from the period you have applied, not from the period you have been using it. Also, in some scenarios, it might be possible that a person has been using the trademark from a period of 10 years, but he did not register it. Now he wants to register it, but a similar trademark is registered 3 years previous to us. But the trademark office would give priority to the person who has been using since a period of 10 years. For that, you need to present in some evidences like bills, or maybe some other kind of evidences, or government receipts, or any kind of taxes or something of that sort, which you have been proving, which would be used in proving that you have been using a trademark from a longer period of time. Coming to the patent part, in patents, there is nothing such thing as proposed to be used or from which period it is going to be used. It is just an elemental thing that you have made something new. And when you discover something new, maybe a new invention, maybe a new product, or maybe some new design which you have invented, so it goes into the patent, and you are given a patent for a period of 20 years. Trademark is given for a period of 10 years. Now coming to the literary part, like books, maybe source code of a mobile app, these all things are protected through copyright. So anyone now has any questions on trademark and patent, so you can tell me right now if there are any questions on trademark or patent.
Participants, if you are having any questions, you can ask to sir by raising your hand, or else you can write it in the chat box also. Sir, I think no one has any queries.
Yeah.
We can proceed.
So this stage is completed in the final days of law school, or preferably after law school, that students start to think, okay, which all field I need to take into and what I need to go for. So what students can do right now is, through your internships, you may have established a list of positions that you are interested in. Keep in mind that how you want to go for one particular field into IPR, then going from another particular field, make your pros and cons, how much you can get into that.
Sir, there is a question in the chat box. Should I read it out?
So, Mr. Govindam, if some other person has a trademark and not trading under that trademark, and we want to acquire that trademark, yeah. So, if a person has been trading for that trademark, for example, for a period of 10 years, but he doesn't have the trademark, a similar trademark has been registered by someone 2, 3 years, 4 years, or maybe 7 years before. So what you can do is you can raise an opposition on that trademark, file in your new trademark, and prove in the user date that you have been using that trademark from a period of 10 years. So when you prove that the trademark has been used for a period of 10 years, so the trademark office could give you a priority and revoke the trademark of the person which was granted 7 years back. Am I clear on my point, Mr. Govindam?
I think it's clear, sir.
Anyone has any other doubts?
If anyone is having any doubt, you can ask to sir. You can write it in the chat box. Someone wrote section 34 covers that part.
Do you want me to elaborate on section 34?
No, sir. I was just stating that section 34 covers that part what you have explained.
Prior use of the trademark or maybe
Yes, sir.
user date. Okay.
Yes, sir.
So honestly, there are no set parameters to decide this, which field you want to go for, but it all depends upon your interest. So let me list down 3 people whose stories would inspire you to be an IP professional. One is Justice Gautam Patel of Bombay High Court. One is Justice Prabhas Videvan, former judge of Madras High Court and former chairperson IPAB. And Professor Shamnath Bashir, founder Spicy IP. So first, let's take an instance of Justice Patel. Honorable Justice Patel, reading his judgments would remind you of your jurisprudence classes in law school, which would emphasize 3 elements of legal reasoning: law, logic, and coherence. Honorable Justice Patel's judgments are strong and measured on all these fronts. So what you can do is, you can go over through the judgment, so you would get to know, okay, in the field of IPR, what all renowned judgments have been pronounced. Like there was a case between Picnic, PIC-NIC versus PIC-NIK. One was a brand of one of the big MNCs, another was also a brand of one of the big MNCs. But they both were using the same brands, and it's similar, and it's nautically similar, because when you pronounce it, it's Picnic and it's Picnic. But the spelling difference is PIC-NIC and PIC-NIK. So what at the end of the day, Supreme Court gave a judgment is both of them can use their trademark because both the trademarks have gained a particular identity and they are recognized by the customers from their own logos and trademark. For a trademark, it only doesn't matter what wordmark you have been using. Harshit, I will get back to you on this. So it doesn't matter what particular wordmark you are using. It also depends upon the logo, which differentiates you from every other person and every other brand which is in the market. So what are the constituents of a good trademark? A good trademark should contain 2 things which are not similar to any other trademark which has been registered in the portal. The first thing is the logo. Your logo should be unique and it should be distinctive and it should not be similar to any other logo. Second, the wordmark which you have been applying for. If you are applying for a similar wordmark, then you should know that there would be an objection onto that. Then there might be an opposition also onto that. And also the tagline. Whatever tagline you are using, you have to be very careful with that. There was a similar case. There was a company in Sitapur, Uttar Pradesh, which was making rusks, which we eat in the breakfast and anything. So what they did was, they use a tagline called "Everyday Rusk." So what Britannia, Good Day, and Ever Ready did was they opposed it. They opposed the trademark, saying that the tagline "Everyday Rusk" is similar to Britannia's tagline, which is Good Day, Day, and Ever Ready says it's also ready, and it's also say every day. So day, they again opposed it. So in case you are choosing a trademark or a wordmark, trademark comprises of 3 things: wordmark and a logo and a catchy line which you would be using. you need to make sure that all these three lines are not similar with any existing trademark, because if they are similar in any way, there might be an objection or an opposition. Even if you get over through an objection in the section 9 or 11, you might face an opposition, and that takes a lot of time and energy to resolve it. Harshit, hope I have answered your point.
Sir, there are some more questions. Like,
Yes, sir.
There is another one question, Aditi. How do we get an internship in IPR, as most of the firms ask for experience which we don't have being a student? Okay, so I would say there are many firms which give you into IPR internships and everything. I think so. And if you do not have any experience, what you can do is generally go over through the trademark portal. Try to read into the trademark portal, because IPR is the only field of law in India, I would say, which has everything online. But if you go over to the online portal and you try to read something, you would get the basic knowledge. In every other thing, you need to go to code, learn through a senior. But IPR, I would say, is something which you can learn on through online. So when you have a basic knowledge, like I said, trademark search, patent search, if you have a knowledge of trademark search even, then any of the firms would be willing to give you an internship in that. And I can recommend some firms to LawInternships, and they can just put it on their LinkedIn page or maybe some another page, and they can guide you that, okay, you can go through them. Can there be a trademark on the look of a mobile application? Yes, Mr. Govindam, there can be a trademark on the look of a mobile application unless and unless such trademark is already registered, which has a look of a mobile application. And we have recently filed and got a trademark which is of the look of a mobile application. And we got it in Delhi also, and one of the persons trading in Delhi and one of the persons is trading in Kanpur, and both of them have got that application. Can a registered trademark be removed? Yes, Shreyam, the registered trademark can be removed, but it won't be, I wouldn't term as removed from the portal. It would be abandoned or it would be rejected. When you get a trademark registered, you get a certificate, so it's registered. You can file an opposition, so it would go into rectification file. That is a stage called rectification. And if you win the case, so after that rectification is gone, it would be termed as removed or abandoned. Mr. Govinda, example of which one? Your question or the Shreyam question?
I think the previous question, sir. Here it is.
Yeah, you can search over for mobile wala. You might get a look of that, or maybe something with mobile. You can search in that particular field. You would get many of such trademarks which are with the logo of a mobile application, and it would be easy. But there would be some difference in the logo. It wouldn't be a very similar logo, but the logos would be on a different basis. So before securing a internship in IP firms for the first time, it is necessary to have some prior skills related to IP or just basic knowledge of IP in some way. I would suggest that some basic knowledge should be there, like trademark search or a patent search, because you can do it on the portal only, and it would help you that when you put it in your CV, so the person who would be hiring you for the internship or who would be giving you for the internship, so he would have an idea, okay, this is the thing, and that is being done into. So you would get to know, okay, this person has trademark search, so whenever we can send them a logo or maybe a business description, so they can just go over through the trademark search, and they can conduct a trademark search, and then they can prepare a report about the 45 classes. So it would be easy for you to grab an opportunity. Vivek, should we register our trademark immediately after opening the business, or should we wait for business to grow so that people will utilize? I would say you should register the trademark immediately, unless you are sure about that a business would be successful or something you are starting, which is not I would say, like startup people, they register the trademark the next day only. But if you have any second thoughts in your mind, okay, let's see for 1 or 2 months. So maybe for a period of 6 months, you can see into it that how much your business is running, and is that there is only over a turnover or something of that sort, how much profit your business is making. But I would suggest that you should register your trademark within 3 months of opening your business. Because at the end of the day, when you're using the mark, for example, there is a company called Decor, which sends handmade household items like candles, design candles, and all other things. So what they did was they registered their business and did everything, and for a period of 1 year, they did not register their logo. So what happened was when they were selling on Amazon or Flipkart, so what happened was similar people were using their names and selling it. So at the end of the day, they had to go for trademark, and then they got the trademark. But for that period of 6 months, their sales were disrupted because people were not able to get which is the genuine decor with which they are trading. So yes, if you're going for online business, I would say it's very compulsory to get your trademark registered, because online the people would recognize you by your name, by your word mark, or by your logo. They wouldn't go for it might, because see, in general terms of business, your company would be XYZ Private Limited, or maybe XYZ Partnership, or ABC Sole Proprietorship. But your trademark would be the thing which you would be recognizing it. So you are using word, for example, uh, if you are using the word example kitchen, okay, and but your company is registered with the name of ABC Private Limited. So people are going to recognize with kitchen. So on Amazon, if someone uses the word kitchen, so they are allowed to use that. You wouldn't be the sole sender. And obviously, being a consumer, you all also shop on Amazon. We do not search, okay, which company is supplying us and which company is perfect. So you wouldn't know, okay, the previous time I ordered, the quality was really good, and now the order I ordered and the quality is gone. So customers will have this feedback, and you would be thinking, what happened wrong? So someone would be using a similar name in that. What kind of jobs can we look for in the field of IPR right after graduation? Okay, so they can be a patent analyst, they could be a litigation job in patent or trademark, they could be a job of patent valuers, trademark attorneys, licensing specialists, patent LPOs, patent drafting specialist, and copyright specialist, or maybe a design application specialist. And I would say geographical indications is something which depends upon the natural resources, but they are very limited and few people in India who have been dealing with GIs. So there are, I would say, in the field of IPR only there would be 10 to 12 designations or job profiles in which you can get into. The truth is rather different. The legislation governing intellectual property is always changing. Every technical advancement, every copyright application submitted, and every example of unfair competition that makes news changes its shapes and size. In addition, procedural IP laws follow the territorial principle. Getting a job in IP legal company is not very straightforward. You need to be very detailed about the field you are choosing, and the field you should have very deep knowledge into that, because any mistake, like in code, if I would say there is some fault, you can get it rectified. But in IP, if you commit a fault, so it stays on the portal, it's online, and it cannot be rectified on that very easily. So you have to go to high court, or maybe a IP court or something of that sort. That okay, so this is the scenario. It was a mistake, and we need to change it. For example, registering of trademark. People generally register trademark on their own names rather than registering it on their names of their companies. So what happened is, sometimes you register on your own name, and that partner of yours, or maybe in the name of partner, is leaving the company. Now, again, getting a whole thing transferred is a very lengthy process in the name of the company, and it is also highly expensive. Sir, is it a crime to use someone else's trademark? No, I wouldn't say it's a crime to use someone else's trademark. It's an infringement. And I would suggest that the person shouldn't be doing that, because it might be possible that if you're infringing someone else's trademark or maybe a patent, you can have severe fines, maybe up to 10 CR or 20 CR. So, yeah, you shouldn't be using someone else's trademark and doing the business, because at the end of the day, whatever you have earned can be put in as a penalty, and the court can order that, okay, you've given all these things. So what role in this trademark attorneys play? They conduct raids. Trademark attorneys are authorized to conduct raids, and they conduct raids in such things, and then they seize everything, and then court has to decide on it, but there is a fine and it's huge. If two or more people use a similar trademark, may not be exact, and both of them are not registered, who will be given more priority on more basis? The person who has been using trademark priorly would be given a priority share sheet. And if the trademark is not registered, see, first of all, both have to go for registration. If only one is going for registration, then other will lose depending upon the date. If his user date is before and he can produce evidences and he can have that user affidavit, then it's fine. But अगर वो previously नहीं use करा, दोनों ने 2020 में चालू किया, एक ने register करा लिया, एक ने नहीं कराया. So I'm sorry to say the other person could use the opportunity of getting the trademark registered. Can a non-profit company apply for trademark? Yes, why not? Many of the people like Indo-Islamic Cultural Foundation, many non-government organizations like Humans for Change have registered their trademark. It's very easy and it's given a unique identity for that part. Yes, government companies also can register for trademark. So, attorneys with technical degree have a minor advantage in the job market. Because in the field of IPR, if you are from a science background, I would say you get an edge over to normal lawyers or maybe who would be from commerce or arts or humanities background. So if you are from a science background, you would always have an edge over IPR field. So you would always be preferred in the field of IPR if there is any job opening. Can a person change his trademark and someone else can take it? First of all, if a trademark is registered, it cannot be changed. The logo or the mark you have applied cannot be changed. You need to file a new trademark. Someone else can take it. No, once it's on the portal, either it is abandoned or either it's objected or it's rejected. So if it's on the portal, so no one else can take it because it's already rejected. So you would apply for the same trademark, you wouldn't get the trademark share.
Sir, there is one more question before that question by Mohit Maru.
Okay.
Can you tell about
well-known trademark and trade secret? Well-known trademark, you can take any example of Wipro, Reliance Industries, any of them. These are well-known trademarks. Trade secrets is a totally different thing. It doesn't matter. It doesn't. It is not related to trademark anywhere. Trade secret is anything which you are doing in your business. For example, if anyone is organizing any kind of or working or has any business or corporate house, whatever discussions that happen, for example, shareholders list, for example, the technology you're working on, or maybe your technical team is doing some kind of research and development, or any other kind of thing, maybe accounts book or something of that sort. These all things are called trade secrets because these are not registered somewhere. By default, Supreme Court has given a judgment, these all combined for the trade secrets thing. If you are into a business of like book publishing, so in that way, if you are publishing your own book, you need to get a copyright. If you are publishing someone else's author's book, so that particular author has to get a copyright and sublease it to you that you can produce this much copies of the books and then you can circulate it to one person or you can sell it on a public basis. So it is multidisciplinary. There's too much to study into the field of IPR. But if you put it into one particular field, so it would be very easy. Someone has any other questions?
Yes, sir. There is one more question in the chat box.
Which one?
From Shreyam Chandrakar.
Can a person change in trademark and someone else? No, I said no for that. A person cannot change a trademark. Once the trademark is applied, you have to reapply for the trademark. Then only you would get to know about it. And the if a trademark has been applied and it's not granted, if it's registered, then it's yours. And if it's not registered and it's expired, then you cannot. No other person can take the trademark which is already on the portal with the name of some other person. So regardless of how much you study a subject, there will always be a new law that a lawyer must study when they first start practicing. Understanding the overall framework and how to negotiate with general sorts of subject matter such as statutes and case laws, it's best in your interest that there are varieties and responsibilities under IP law, which come on a very day-to-day basis. For example, if you are applying for a patent on behalf of your company and you have applied the patent, now the patent has been published. One of the rival competitors has also applied for a patent. So how would you get to know that okay, another patent has also been applied? So on a day-to-day basis or on a weekly basis, you need to search the portal. You need to know, okay, I have to conduct this search. I have to make sure that this thing is being done. Else, if you miss one thing, for example, you applied for a patent, your patent is going on a slow process. And another person has applied on the patent and he has expedited the patent, he has expedited the examination, and the report has been published and it's granted. Now his patent is granted and your patent is still published. So each and every step in patent or maybe trademark or copyright is very crucial, and you need to be attentive all 24 into 7, 365 days that you do not miss an opportunity. Because IP is all about opportunity. If you miss the opportunity, then it might be a loss. It's not just the loss of an IP, it's loss of a property. Intellectual property, बौद्धिक संपदा का नुकसान होगा. यानी नुकसान would be business loss, opportunity loss, or maybe many other things. You wouldn't be able to do that business also. Please shed some light on trademark of non-descriptive things. So, trademark of non-descriptive things. Mr. Govindan, can you be a bit precise on this because it's a very vast thing?
Yes, I was just wondering, can we trademark a sound or a smell or a taste?
No, I do not think so. That, you should have a particular logo over there which describes this thing.
Okay.
For example, you can have a generic or a very generic trademark like which these are not generally granted, like fatso, or maybe in the name of how would I put it into industrial design. Industrial design is a very common term. It's not very descriptive, and you can just put in industrial design and you might get a trademark. But yeah, it is very possible that this is objective because a non-descriptive trademark is not generally granted by the attorneys unless and unless it has made some brand value of its own. So I'm going to cut the long story short by now. Some of you would probably be wiggling in your seats. We're waiting for the speech to stop. Whereas we might have a few of those eager ones among us who are inspired by the information presented today, and they want to pursue IP laws and become one of the attorneys or maybe agents in the field of IPR. We don't want to obstruct either, so we will move on to the moral of the story, which is that the IP laws are essential. And in India, it's on a booming phase, and countries have strong laws and practices, and IP laws are purely valid in international conventions. Like for trademark, there's a Hague Convention. For PC, there is a Patent Convention Treaty. So, unlike normal laws, like if you do something into CRPC or CPC, and if you go outside India, the laws change. But this is not the scenario in the case of IP laws. If you are doing something in India, the same laws goes for the convention treaty, which has been signed by 146 countries or maybe 154 countries, depending on trademark, copyright, design application. So all these countries have similar laws. So sitting in India, you can practice in this field and you can apply for all these things internationally also. So it's a very vast exposure for you if you are choosing to become an IP thing. Geographical indications in a very layman's language, I would say in West Bengal, Rasgulla are famous. So that is called geographical indication. महाराष्ट्र के केले बहुत फेमस है, तो वो geographical indication. आप उसको वहाँ के geographical indication के हिसाब से कर सकते हैं. जो चीज एक particular geography में ही पाई जाती है, उसको हम GI कहते हैं. Registration अगर आप prove कर देते हैं कि ये चीज यहाँ से ही पैदा हुई थी और सिर्फ यहीं पे पाई जाती है, now it has gone into several branches and everything. So that's how I would say there was a very famous case, but it is not of GI, it is of patent. US tried to patent haldi, so that it can be sold in only US, or maybe they can license it further, one of the companies in USA. So what Indian government did was that they tried to prove that the haldi which they are using, or which you are using, the US people are using, it's very, very generic. India has been using it since many, many years back, and we have the proof for that. So the patent was not granted at the end of the day. So this is also an example of GI, but they try to file a patent over that. If they would have filed a GI also, then we could have also proved that, okay, no, GI of haldi belongs to India. So anyone has any last questions? Anything? Any doubts?
Sir, if I may, I have an example of GI to allow that.
Yeah.
Yes. If you, I'm aware that you must be aware that champagne can only be sourced from Champagne in France. So any sparkling wine called champagne only has to come from France. That is why all Indian brands which are champagne are not champagne but marketed as the sparkling wines. So that is one example of geographical indication.
Yes. If you go into wines and everything, so Scotland would be there. So that's the thing. So anyone has any doubts, any questions? Sorry?
Sir, there is one more question in the chat box from Mohit Maru.
So like in patent, when it is granted to a person, or he or she can give the rights or for use of that patent by some other company in exchange of money. So can the same be done with trademarks? Yes, the same can be done with trademarks even. You can apply a trademark in your name, and then you can just lend the trademark by a deed to a company which can use that particular trademark. So there's no problem in that. You can do that. Same goes for the patent also. So I guess it was a very nice session, and
sorry for the interruption, but there is one more question
yeah.
From Uditi Ghosh.
So can you enlighten us on a bit on arbitrary trademarks and something not really talked about? Can you be a bit, Uditi, can you be a bit focused on what kind of arbitrary trademarks you're talking about in the field of manufacturing or in the field of services? Okay, so for example, let us take an example of computer maybe. So let's see an example in the form of Apple. Okay, let's go with an example of Apple. So Apple, when Apple applied for its trademark, so it is an example of arbitrary trademark because Apple is a fruit and stands for a fruit, and the logo in itself is a fruit. Okay, but it has been granted in a different class, which is of mobile, iPad, computer, and other applications. So these all are called like arbitrary trademarks. These because they do not have any existence or any relation with the business. For example, tomorrow you launch something called pineapple shoes. So pineapple is a fruit and shoes is nowhere related to it. So that is what is arbitrary trademarks. You're applying for a logo which is related to some other thing, but you're applying your business. For that business, you're using that particular logo, and it has nothing to do with that business. Apple, or maybe you can take another example, I would say, of what can I say? Shell lubricants. Shell is the shell which we get into from the sea, and Shell lubricants or maybe Shell gas station has nothing to do with the word shell which they are using. And similar thing can be in the form of Seidel. Seidel is something different, but it's generally used with non-alcoholic drinks. So could you give me the case name of turmeric example? That I would also have to Google it, but yeah, let me just give me a second. Okay, US patent 5401504 was granted in March 1995 for the use of turmeric powder as a wound healing agent. The Indian Council of Scientific and Industrial challenges its patent in October 1996 on the ground that it did not satisfy any important criteria or novelty. For a patent, you need to be novel because if or anything is already in existence, so it cannot be granted as a patent. So the novelty of that turmeric was not there because we have been using it as a medicinal herb from a longer period of time. So you can just put in on the Google US applied for turmeric patent, so we'll get all the details. Anyone, anything else?
Participants, if you're having any query, you can ask to sir, or you can write it in the chat box also. I think no one has had any query more. Sir, one more question by Harshit Raj Singh.
Students who are really interested in this field, how can one become good in the same? I would say it would require doing internships in the field of IPR, working under an IPR attorney, and getting to know about things which are related to that. And you need to do a lot of research work, operate trademark portals, IPR portals on your own, try to search in, read the Trademark Act or the Patent Act. It's a very generic act and it's a very easy one. It's not like the other acts which we all have been dealing with, like CRPC, CPC, or maybe arbitration. So it's a very easy act, and the only thing is you can how as many internships as you can do in this particular field. And if you're from a science background, so from the first day you can go for patent agent papers. There are examinations which are conducted on a 2-yearly basis, and you can clear that examination. You can become a patent agent, and there are many big law firms who will be willing to hire you on that basis.
So, participants, if you're having any doubt, you can ask to sir. I think there is no more questions, sir.
Okay.
I hope.
Thank you everyone for having such a wonderful session, and it was very interactive and many of you have asked questions. In case of any doubts, anything, contact LawInternships.
Yes, sir.
And any feedbacks, please let me know.
Yes, sir. So further, I would like to move with a vote of thanks. On behalf of Team Law Internship, I would like to extend my heartfelt gratitude to Advocate Gautam Pratap Rai Matani, sir, for taking out time from his busy schedule and interacting with the young minds. It was truly an enriching session. Thank you again, sir, for sharing such wonderful experiences and knowledge with us. Thank you, sir.